Great. Let me join David and Neil in thanking David, Dean, the other organizers, and Naomi and all of you for this panel. I said I would talk a little bit about some of the comparisons and some of the distinctions between positions that the Obama administration has taken on some of the questions we're talking about today and positions that its predecessors took. You know, I think it's been a very popular subject of popular commentary, media, talk show, radio, et cetera, for individuals who oppose the current administration to point out how similar some of its policies are to its predecessors, and for individuals who support the current administration to attack it for the same reason. And what I want to do is suggest that I think there's a lot more nuance here than these 30-second sound bites usually allow for. First of all, I don't think it's the least bit surprising that the Obama administration has defended the merits of the government's position in the Guantanamo cases. It has been, it will be, I think, the administration's position that we are in the middle of a war and that the laws of war apply to that conflict and allow the detention of some individuals. But that's not to say that they are taking the exact same position. For example, the administration has not argued as vigorously that the laws of war have no bearing on these cases. The administration has not argued as vigorously that the detainees have no constitutional rights whatsoever. Indeed, even after Judge Randolph's opinion in Kiemba 1, which specifically states that the Guantanamo detainees have no due process rights, notwithstanding Boumediene, the administration has chosen to cite it without really relying on it. Now, you may think that's a semantic difference. I think that's actually a fairly different theory about the relevant legal framework. They cash out the same way. In both cases, the administration thinks it has the power to detain, but for very different reasons, and I think there's deep differences behind that. Nor is it surprising to me, although I will confess that it's disappointing, that the Obama administration has also defended similar positions vis-a-vis the scope of the state secrets privilege, especially in the Al Haramain and Jeppesen data plan cases in the Ninth Circuit. I think any president likes secrets. Whether they're a Democrat or Republican or a know-nothing. I think the more serious question is the separation of powers question. Right? The Bush administration was on record as thinking that the proposed State Secrets Protection Act would be unconstitutional. The Obama administration has been far less, shall I say, clear as to its view on whether legislation is desirable and or permissible. And I think one of the hard questions about the state secrets privilege, which has actually sort of lurked below the surface for the last year or so, is not whether there should be a state secrets privilege, but how much it can be and should be circumscribed by Congress. And at least there, I think there's been a marked difference between the current administration and the previous one. Even with regard to military commissions, the current administration received an awful lot of criticism from the left when it announced that it was going to continue to pursue military commissions. It then fought for rather non-cosmetic changes to the Military Commissions Act, even though only a few of them actually made it into the final language in the 2009 MCA. Now, to be sure, I, for one, wish the administration, as a matter of policy, would not be so quick to fall back on commissions. And I also think there are serious constitutional problems with some aspects of these trials, some of which were aired yesterday before the Court of Military Commission review in the Al-Balul appeal. But to suggest that there's no difference simply because both administrations think military commissions are sometimes permissible is to neglect the real differences in the arguments. The Obama administration has not argued that the laws of war are completely irrelevant in understanding the scope of military jurisdiction. To the contrary, they've argued that both on their own and as interpreted by the Supreme Court in the Hamdi and Hamdan decisions, the laws of war have a lot to say about who can be tried for what offenses and under what circumstances. Now, I suspect there are lots of people in this room who will disagree with that belief and with that view of the law. But I think we have to separate out where we disagree with current policy from assumptions that the current policy is no different from the previous one. And in general, I mean, I think this is the big point. There is just a more fundamental and foundational difference in the Obama administration's approach to constitutional arguments vis-a-vis executive power. Gone are arguments that Congress can't legislate in these areas, or that the substantive scope of certain congressional statutes is entirely irrelevant because of the president's inherent Article II authority. This still cashes out the same way in most of the cases on the ground, and that's okay. It doesn't mean it's a semantic difference. It is a very fundamental difference, and it focuses the legal issue, as it always should have been, on the question of whether the government as an undivided whole has the power to do what it's doing. and not whether the separation of powers have been properly respected. Now, let me just say a word. The benefit of going third is I can sort of adjust on the fly to what others have said before me. David, in his remarks, suggests that the D.C. District Court has run amok. And I want to suggest that to the contrary. Even as the district courts have disagreed in these habeas cases post-Boumediene, 32 of the 41 detainees whose cases have reached the merits have prevailed. To me, that is a staggering number. That means that in 32 of the 41 cases of individuals who were still at Guantanamo after 7 years, when the evidence finally got before a neutral decision maker, the government could not carry its burden in over 75% of the cases. These are the same judges who in 2005 wrote that there was no viable legal theory on which the detainees could prevail. Now, some might think this is madness because these lawsuits lack merit. And I think that's an argument that is now belied by these results. Others might think that this is madness because the merits of these suits are simply irrelevant. That's a position that I think is a perfectly fair one to have, but it's one with which I respectfully disagree. And one last point on Makala, the Bagram case. I think it's important to remember Neil summarized the government's argument, but he left out one rather significant distinction. The 3 detainees at issue in Makala were not picked up in Afghanistan. They were picked up somewhere else in the world and transported by the government to Bagram, to the battlefield, to harm's way. Now, I actually think that the government has plenty of authority to hold individuals as captors in Afghanistan, and perhaps even to hold them with very limited habeas rights. But to say that that would apply for anyone picked up anywhere in the world is to turn Guantanamo into an accidental mistake, and to suggest that anyone, no matter where they're picked up or what they're doing, can be sent off to Bagram with no habeas rights. I think that's not what Justice Kennedy had in mind when he wrote Boumediene. Again, we may disagree about whether Boumediene is rightly decided or not, but I think we have to be fair, at least in respecting it as the law of the land. Now, the part of this panel that I find really, really telling is the last part of the title. Where do we go from here? Neil's right, there are very hard questions back of all of these disputes. Questions on which reasonable people have, can, and will always disagree. And what I want to suggest is that I think we just have to be careful to separate out political rhetoric from principled disagreement, right? Because one of the things that national security debates tend to show is how easy it is to lose nuance simply because you voted for somebody else. That was a criticism that was leveled at lefties during the Bush administration, and I think it's turning around now. With regard to the future, I actually think the real question, the hardest question, the one that we should, perhaps even devote some of our Q&A to, is what to do in cases like Abdul Muttalib, right? I mean, here we have someone who is caught literally in the act, who is probably prosecutable in a civilian court, who is probably subject to the laws of war. And so the administration has a policy choice to make, right? And I think the question is, what is the best policy? And I think we'll disagree. But what I want to suggest is the one thing that I would be troubled by, and I think the one thing we should all be worried by, is any policy where the administration can repeatedly bounce someone back and forth between the criminal and military justice systems to manipulate those systems to the best possible end. That's not a system that I think we should support, and I think that's why this case is so tricky. So I look forward to your questions. Thank you.